in litigation readiness, privilege, and ethics in the digital age. Thank you for joining us. My name is Carolina Pinheiro, and I lead corporate governance and securities at Verda, a company focused on reversing metabolic disease through nutrition. My role is to help the company scale quickly, but in a way that is also defensible, which is why this topic is especially relevant to me. Before we begin, a quick thank you to Buchnan for being a valued ACC Gold sponsor since 2024 and supporting today's program. Buchnan has especially deep experience in the energy, finance, healthcare, and life sciences industry. We are joined today by two outstanding speakers, Gretchen Jankowski and Jason Nurtag. With that, I'll turn it over to Gretchen and Jason. Thank you.
Thanks, Ron.
Thanks, everyone. Jason and I are thrilled to be here today. We welcome everyone, ACC members, non-ACC members, and we have some clients that have joined today. Just by way of brief background, I am co-chair of Buchanan's litigation section. Been in that role for well over a decade. But as a litigator, I think you need to know that because you understand sort of how we're coming to this program. But I litigate all kinds of cases, mostly in federal court, plaintiff and defense side, anything from antitrust to franchise, commercial disputes, you name it, I've touched it by and large, primarily because at the end of the day, one of the things that we specialize in is parachuting into cases to get them ready for trial, whether it's bet the company cases or otherwise. Jason comes from a similar but a little bit different background, so I'll let him introduce himself.
Yeah, and thanks everybody for joining us for this lunch session. My name is Jason Murtaugh. I am the head of our San Diego office. I'm also the chair of our West Coast employment practice. I'm trained as a litigator, but most of my work now is in the employment space. We advise companies on how to navigate California's labor code, and then we defend you when you have PAGA claims and class action claims and a whole variety of other things. So really appreciate everybody joining us today. If you have any questions, please put them in the chat, and we'll try and get to those. But otherwise, Gretchen, why don't you kick us off?
Yep, I will do that. So what we're talking about today is what we'll call the fascinating and sometimes tricky world of record keeping in our digital age, especially because obviously this is an ethics session. So the good news there is you're getting ethics credits for this. As it relates to your duties in-house when faced with litigation, or for that matter, an investigation. So we will be exploring today some of the pitfalls. We'll also provide some suggestions as to how you can stay compliant. And we want to give you some emerging examples because the landscape in this space is changing rapidly. Everyone on the call we know knows what a litigation hold is. When that duty in general arises and what happens when that goes out in terms of preservation. We know years ago this was really easy. What did it mean? Don't shred your paper files. Obviously, it's a lot more complicated. We do know that everyone on this call is well aware that in this digital age, it definitely means emails. But it means a whole lot more than that, and that's some of the things that we're going to talk about today. To what extent is it going to apply to texts on your employee's company phone? That's a little easier, versus texts that your employees are using on their personal phone but are business related. And what if you use Slack or Teams? Guarantee almost everyone on this call uses some form of that. And so as we go through this presentation, here's a couple of things that I just want to throw out, and Jason and I want to throw out as questions and answer them as we're going through the presentation. So first, once you implemented a litigation hold, did you ensure that Teams or Slack messages were in fact preserved at the time that was issued, before your outside counsel raised the issue? Second, did your outside counsel raise the issue at all? Third, if you're an institution, and some of you are, that record calls with customers after the litigation hold was implemented, what did you do to ensure that those recorded calls were in fact preserved before they were deleted in the ordinary course? And then after litigation ensued and the hold was issued, what did you do from an in-house perspective to find out who your custodians were, what type of phones they were using, did they use text messages, and how were they going to preserve them? And one of the reasons we want to talk about that is we know people get new phones on the regular. And the excuse that is becoming less and less acceptable in courts, and there are a lot of decisions on this, is, oh, well, I got a new phone, therefore I don't have text messages anymore. So with that, I think we're going to start a little bit with the basics and talk about modern record keeping. So, Jason, you want to kick us off on that?
Yeah. So let's go back to basics. And the good news for everybody is that a company has the absolute ability to set up its own record keeping and its own internal processes however it likes. And there's a great discussion in the Google antitrust case from a couple of years ago that goes through that. The question isn't whether you can set up a particular system. It's what you have to do once that system is set up. So with the freedom to choose your own systems, the court held, comes the responsibility to know what's happening with those systems going forward. And that's become, over the course of the last 2 years or so, even more omnipresent. We took a look at some recent statistics as of April, and this blew my mind at least. Microsoft Teams has over 320 million users, with over 8 million companies in the country using them. And that includes over 93% of Fortune 100 companies. Slack is a little bit smaller. It has 47.2 million daily active users, but 750,000 organizations use Slack as well. And so the court said, with freedom to set up your own system comes responsibility. And so if you are using, like we all are, internal systems like Slack or Teams, those are almost always going to be discoverable if used for work purposes. And that's specifically what was addressed in the Google case. The court in that case was very concerned because Google had a lax policy for chat preservation. What Google had done there, according to the court at least, was to permit employees to decide which of their chats they were going to keep and which they were going to delete. Obviously, that is not acceptable, and the court held so. So, the other thing that happened in the Google case is that Google had what they called a don't ask, don't tell policy, which contrasted with their email policy, which was automatic and very thorough. So the company had developed a really great process of preserving emails, but really had an ad hoc approach to preserving the chat communications. Finally, and this is, I think, important, the court was concerned about what it called an internal training program that apparently someone, hopefully not the legal department, but someone had presented an internal training program to all of the employees, telling them that they ought to use things like chat rather than email because they were less likely to be discovered. We all know, and we all advise folks, including your business folks, that some things should not be put in writing. If you're going to have an internal program to tell people not to put things in writing, don't put that internal program in writing either. That created some real headache. So on this next slide, slide 5, we've tried to provide, and by the way, these materials are available at the ACC website. That link is in the chat. Some examples of the kinds of things that may be discoverable and the kinds of things that are not discoverable. So on the left-hand side, you'll see that internal instant messages, emails, instant messages, text messages that are on a company-issued phone, and some training materials are generally kind of discoverable. I want to let you know there is one case that we did not include specifically on the chart. It's called Tello versus Lee. It's just a couple months old out of the District of New Mexico. I can give anybody the site if they want it. But the court in that case talked about a company's duty to turn off the automatic deletion features that a lot of programs have. And I will admit to apparently not being terribly tech savvy. I did not realize until we began preparing this that several programs, including Teams and others, have a default by which every certain number of days, the materials just disappear forever. Now, that obviously makes sense from a record-keeping perspective, but once litigation happens, that can be a real problem. So you need to familiarize yourself or have your tech teams familiarize themselves with each of the technologies that are being used. And we need to know what the default deletion features are so that we avoid a situation in which stuff has gone away and we don't even know about it. So on the right-hand side, what's not discoverable, the kinds of things. Really, I think, we've given you some examples, but fundamentally it comes down to the question of control. Do you, as the company, exercise control over the particular devices or the particular information that's in question? So company cell phones, you control those, right? That's almost always going to be discoverable. If your employee has a company-issued cell phone, you can call them up and say, Bob, I want your cell phone. You have to give it to me. And you can get those. But how about personal cell phones? If you have a bring your own device policy like most of us have these days, what about those cell phones? Well, as with everything in law, the answer there is maybe. There is a split of authority in terms of whether companies have to take steps to preserve information on personal cell phones. And the distinction that the courts have recently drawn are between two different tests. One is called the legal right test, and the other is called the practical ability test. I won't bore you with all the details, but for purposes of your CLE credit, the legal right test just questions whether the company legally would be able to get that particular information or device from the employee. If you've got a handbook that says, we can get this from you, you don't have an expectation of privacy, all of those sorts of things, that can lead a court to find that you as a company have the legal right and therefore have custody or control over that information. The practical ability test is, as its name suggests, much more practical. It questions whether in the ordinary running of your business on the day-to-day, does a company, practically speaking, need or expect to gain access to the content of your employees' text messages on the personally owned phones? If you don't, if people have their own text messages on their own personal phones, and throughout the course of ordinary business, you never need those, you never expect those, you never get those, then you're much less likely to fall into that practical ability test that the courts have recently imposed. I do want to add a little footnote here. Some courts recently have sort of thrown out both of these and said, we're going to reason backwards. In other words, we're going to say, you need to be able to exercise control and produce information from your employees' personal cell phones, because otherwise you're going to do what companies will do, which is you're going to tell everyone to move their communications off of the company devices and to take place only on personal devices. I think you can inoculate yourself somewhat by having policies that say that company communications ought to take place within the company communication methods. I think it's important to think about your policies and your handbooks along those lines. But do be aware that if you've got a lot of people doing a lot of business offline, that's going to increase the risk that a court is going to say you need to actually be able to get those and hold on to. All right, the second category on the right here, employees' personal social media. Generally speaking, courts have found that companies don't have control over employees' private, personal social media accounts. If they have a company LinkedIn account, fine, you may have control over that. But if they've got something on Facebook, if they've got an Instagram or a Twitter that's their own, you generally don't have custody or control of that. Those of you with a bit of a memory may recall there is one famous case where a court went the other way, and that was in the Open XAI case where the court found that Sam Altman actually did have to produce certain personal social media accounts. That was a very unique circumstance, I think, given the nature of what was at issue. Frankly, I don't think his lawyers fought the issue as hard as others might have fought. And so there is that case out there. But as a general rule, we're going to find that you don't have to worry as much about your employees' social media accounts. Now, I mentioned at the beginning, I'm an employment lawyer, and I can't get through any presentation without saying something about employment law. So as you're thinking about personal social media accounts, all of you, for your California operations, remember that Labor Code Section 980 went into effect a couple of years ago. And what is that? Well, 980 says that you can't require your employees to provide you with information about their personal social media accounts. You can't ask them for their usernames or their passwords, or tell them they have to open it up in front of you, or tell them that they have to disclose what they're posting. You can actually face some pretty significant employment law liability if you do that. So again, hold that in the back of your mind in case you're ever faced with a question as to whether or not you need to have a conversation about social media. So those are the general sort of categories we look into in terms of whether you have to preserve it, whether it's discoverable, whether it's not discoverable. And then, Gretchen, can you talk us through what goes wrong if we get this messed up? What's the risk for
Yeah.
us?
Well, there, as you might expect, there are lots of risks. And, in terms, and I do want to talk about it, but I think one of the things that, both Jason and I can say is, so much of what has to get produced in a case is very much dependent on what the factual issues are, and quite frankly, how big of a case it is, right? The bigger the case, in terms of what's at issue, the more likely you're going to have to produce all hosts of data, because a court's just not going to be super sympathetic to the argument that it's unduly burdensome. And so I am finding in a lot of cases, it is more the norm than it's not to produce things that 10 years ago you would have never had to produce. This idea, cell phones with iCloud backups and all kinds of things are becoming more the norm, which is why we wanted to talk about it. So even though there's tests, right? At the end of the day, it's going to depend on the judge and what your facts are. That's almost always the case. But we are going to talk about spoliation because in this day and age, it is almost more the norm than it's not. And what do I mean by that? What I mean is when people think of spoliation, they often leap immediately to the intentional destruction. Obviously, that does exist, and it exists in cases. But in our experience, spoliation often occurs really because people are not being careful. And the ramification of that can sometimes be as severe, particularly in terms of how quickly it's discovered by in-house counsel, outside counsel, and how you handle it strategically in a case. As with, it is not like wine. It doesn't get better with time. I can tell you that now. And often trying to explain to clients their ethical obligations, particularly when the client's an in-house lawyer. Well, can we just sort of sweep it under the rug? The answer is no, you can't sweep it under the rug. Ethically, as a lawyer, we know you can't do that. It's a harder conversation with business people that don't have the same ethical obligations, but outside counsel sure as heck can't sweep it under the rug. So really, the question is, what is spoliation? Basically, it is anytime you have an obligation to preserve something, electronic and otherwise, and you don't do it properly. That's really all that it is. And, a lot of the cases that are really out there are coming really under the federal rules. There's a lot more spoliation cases in federal courts. I think in part just because the law tends to be a little bit more developed. some of the cases have more at issue. But here are basically the predicate findings. And what you're seeing on this slide is, here is the test, and the quotes that appear underneath that, they are all coming out of the advisory comments on Rule 37. So what do you need to establish first? Well, if you're the one establishing it, if you're going against your adversary, you need to show that the ESI is lost. That's often an easy thing to do, to say the least. And 9 times out of 10, if it's not coming out in the ordinary discovery process after a review of documents, it's often coming out as a result of a deposition. It's rare deposition these days where somebody isn't asked about sources of information, really as a check on your adversary. To what extent did you do it the right way? ESI should have been preserved in anticipation or conduct of litigation. I can tell you this, yes, there's a whole line of cases that deal with when is litigation anticipated? When should have known? And the one thing I want to say here, and this is something I tell in-house lawyers regularly, the moment you slap the phrase work product on something, you have now rung the bell on anticipation of litigation, and a lot of lawyers don't recognize that. So do not put work product on what I call lawyer work product. It has a very defined meaning in the law, and too many lawyers put it on things. Don't do that, because you're setting yourself up for an argument. Don't put it on something if you're not actually anticipating litigation, because you may have triggered an obligation you didn't mean to. Everyone knows once that litigation hold goes out that you are now in the realm of having to preserve something. It was lost because you failed to take reasonable steps to preserve. Jason's already talked about some of the cases, but it becomes more of a problem when, from an in-house perspective, you preserve, let's say, emails properly and nothing else. It's because a court can look at that and say, well, you know how to preserve because you did it with your emails. You took control of your employees' emails. You didn't let them delete it because you preserved it immediately, but you didn't do anything with Teams messages. Or worse yet, things that appear like on a Google Drive or a shared drive. All of that really needs to be taken care of, and it's scary. It's really, really scary because of all the ways and places that people store stuff. It applies equally with employees that decide that they're going to use their desktop as their own folder system, and you may not even know about it. Right? I'm a big offender of that, for what it's worth. So it's near and dear to my heart. So it's not just what's on our official system, but it's all those copies and everything else that somebody is maybe storing somewhere else that perhaps it didn't get into the system, and that it hasn't been restored or replaced through additional discovery. I mean, that's the last test. Obviously, and what do I mean by that? Let's say you've collected emails and, one of your custodians basically saved nothing. If it's basically in everyone else's, you're probably going to be okay, even if a singular person did it. But depending on the case, it can be pretty catastrophic in terms of this. But I will say this issue comes up in virtually every case. There is something somebody didn't preserve correctly. It's almost inevitable. And I see it a lot with things like videos, audio recordings, Teams messages, or this is the classic example where somebody knows there's a dispute, an employee leaves, and someone forgets to get those emails, and that computer gets recycled and the emails are all gone because the employee left. It's all of those things that in-house lawyers need to think about, because a lot of times you may not even have outside counsel retained. So prejudice and intent to deprive, I mean, that is the standards, no greater than necessary to cure the prejudice. Well, I have to tell you, it is very broad. Courts have a lot of discretion, and a lot of what they do is very much going to be dependent on how do they think outside counsel has been with them in terms of being straight up when something's gone. Did someone, for example, when they realized there was a problem, identify it in written discovery, identify that something is lost to alert the other side? I mean, it's not something anybody really wants to do, but a lot of these factors very much are weighed by a court. And if counsel has not been upfront and it's basically the adversary that's bringing it to the court's attention, they're going to penalize even more. The sanctions in this type of an arena can be pretty great as well. And some of what you're seeing is actually embodied in the rule itself. You know, you do not want in a case a presumption that the lost information was unfavorable to a party. You don't want that presumption, nor do you want to read about that in a summary judgment opinion, or worse, have that go to a jury as part of an instruction, because that does in fact happen. Dismissal and default judgments. Does it happen? Yeah, it happens on occasion. It's rare, as you might expect, and it's got to be incredibly egregious. But sanctions in terms of monetary awards can be incredibly significant. And what do I mean by that? Sometimes, depending on what a court has to do in order to make this finding, whether it's an evidentiary hearing, it's almost always briefing. You know, it's not uncommon for a court to award your adversary all the attorney's fees that were incurred getting to the issue in front of the court. And I think that's almost the norm, if they find this. And it is rare. I think it is rare where a spoliation has been in some form intentional, even if that's what you would call grossly negligent, where a court isn't going to award sanctions. And I've seen sanctions in the $1 million before in cases, depending on, really depending on what's at issue. So I want to now turn into, a different subject. It wouldn't be a presentation, I swear, anymore without talking about AI. But this is one of those arenas that I think scares us all. And I'll give an example. I had a situation where we were working on a potential lawsuit, and we were asking business people to give us sort of their take on certain aspects of it. I received a document that was AI generated. Now, had we not done some questioning, we might have actually thought that that was, in fact, the facts. But the business person decided it was just easier to take our questions and ask for a response that had no bearing, by the way, to the facts. So the fact that, I've never seen that. It's incredibly scary. But we wanted to talk about it because we do know lawyers and business people are regularly using AI, whether it's Chat GPT, whether it's Claude, whether it's an internal. Lots of companies have their own internal equivalents of Chat GPT. And if you Chat GPT, sorry, and if you have done it before, and we have our own proprietary system called Artifacts, and I've used it. What is amazing to me is the cases that they give me that are not real. They just make up cases, they pull, and we're going to talk a little bit about this because it is becoming a problem for all of us. But I think for in-house lawyers, I think what's scariest from where you sit isn't so much what your lawyers maybe are doing, but what your business people are doing that you don't know about. Are they responding to things using this, and it has no bearing on reality. What's that risk factor for you when they're creating documents that really have no bearing on the facts? And how are you going to fit? At what point in time are you going to figure that out? Particularly if it ends up in litigation. But what we can tell you, and it's all over the news with lawyers, but it is amazing. And there is actually a researcher that's collecting all of this information. But since 2023, there have been over 900 cases in the United States involving some form of hallucinations. And so if you look at this chart, and you can see the source, and this is a source that is cited repeatedly in the news and repeatedly by researchers. But if you look at that data, it's lawyers, experts, judges. They're all affected. And there's all kinds of things that are occurring, whether it's fabrications of non-existent citations, false quotes, so quotes that maybe come out of a case, but not the case for which it's cited, things that are just misrepresentations, or this one's a little scary, and I've seen this in a recent case, outdated advice, where I do believe that the lawyer on the other side wrote something, but they wrote something about a rule that has been superseded like twice over. So obviously an easy thing to respond to, but lawyers are doing this on the regular. Obviously, these hallucinations are leading to things like sanctions, fines, and case dismissals. They're also leading to lawyer discipline. Lawyers are being disciplined by state bars for engaging in this behavior. And what I can tell you is if you look at this chart, the two biggest offenders of this are pro se litigants, which comes as no surprise to anyone on this phone, I'm sure, and lawyers. And again, lawyers, like outside counsel lawyers, certainly not in-house lawyers. And it's not just a problem plaguing small firms. It's not at all. The largest personal injury firm in the country has been caught and sanctioned, and several top AmLaw 100 firms, 50 firms have also been caught with this. And you've seen this in the news. Fortunately, not our firm, knock on wood, because those are the kinds of things that keep me up at night, that somebody's going to do this. And we're not going to be, despite all the training that's given. So, and these are, and I've talked a little bit about the types of hallucinations. And I can tell you from firsthand knowledge and what I've seen, I have seen all of these in cases. I've seen them from lawyers. I've actually seen them from experts. And that's been truly mind-blowing that an expert would do this. And quite frankly, get caught in it. It's a good thing if it's your opponent's expert, I can assure you, and it works exceptionally well in a trial. But all of that being said, in the past, most of us wouldn't really double check our expert's work product. But I think it's one of those things that nobody seems to be immune for it. I did want to mention one of the cases that's coming out of California. It's a 2025 case, California Court of Appeals case. And what was, I think, amazing about that case is it was a typical appeal on very, very basic issues. But the appellant, and it's the Nolan v. Land of the Free People LP case. Some of you may have seen it or seen it discussed. But it was the appellate court that sua sponte sanctioned the appellant's lawyer. It wasn't the adversary who really brought this to the court's attention. I guarantee you it was the appellate court's law clerk that started looking through briefs and realizing none of the cites were real. And so while the court did decide the issue on the merits, They issued a separate rule to show cause and sanctioned the lawyer $10,000 for, in essence, wasting the court's time and submitting a brief that was littered with cases that just were not legitimate. And so courts are, not surprisingly, losing patience. And we all know that even some of the reputable AI tools that all of us are familiar with, whether it's Thomson Reuters, Counsel, or Westlaw Precision, we still need to go and look at hard copy cases. You're not just going to be able to rely on what gets generated. I mean, for anyone that's ever done research, you know you can't rely on the head note, because the head note may not have anything to do with what's actually in the case. So with that, Jason is going to talk a little bit. We've talked about those. Talk about this issue in relation to the attorney-client privilege.
Yeah, thanks, Gretchen. And just before I jump into this, I wanted to sort of reinforce something that Gretchen just said, again, from the employment standpoint, which is, obviously it's terrible if your outside counsel gets sanctioned, right? But the other challenge that you're going to have when AI sort of finds its way in is that there's reputational exposure for the company. And so one of the things that we've been talking to a lot of our clients about is beginning to review your policies, your employment handbooks, and making sure that you have robust internal policies, because some of the bad facts, like in the case that Gretchen handled that she talked about, those can start with the question to the business about what happened. If they're putting information into AI, you eventually have a garbage in, garbage out situation. And at the end of the day, some of this information sort of builds on itself. But let's talk
before we switch to that, you were talking about guidelines, and this brings us to like outside counsel guidelines. Some of you probably have them. Some of you probably don't. You can put in an outside counsel guideline, you're not allowed to use AI. Recognize, though, that practically means you're not letting your lawyers use Westlaw and whatnot. So I think there are lots of ways to draft that to be crystal clear about what it is you actually mean. Because I could tell you, when we get outside counsel guidelines that are that broad, we have to go back and clarify, because there are certain things that you would want AI to be used for. But by the same token, what I think most companies are really saying is it is incumbent on you as lawyers to verify. The excuse of, well, geez, AI generated this, therefore I'm not responsible, is no better than the associate did it, the paralegal did it. We all know those are not defenses. AI did this is not a defense. And so I think that's, from a practical standpoint about what in-house lawyers can do. Think about what your guidelines actually say, what you want your lawyers to do, what you don't want your lawyers to do, and maybe make it a little bit more explicit, because a lot of companies are not issuing guidelines that even address this at all. And you're, from an in-house perspective, are going to want protection there, because that is the last thing you want your outside counsel to do. So with that, Jason, I think we can talk about privilege. Sorry to.
No, not at all.
Yeah.
All right. So we're going to talk about two sides of the coin here. What happens when you give up information? What happens when you try to protect it? Both of which are critical parts of our jobs as lawyers. Everybody knows the elements of attorney-client privilege, right? It's information given from an attorney to a client or vice versa in anticipation of litigation without the presence of a third party who would destroy that privilege. And here's the question. When you start providing information to a machine and asking it questions, are you then disclosing that information to a third party such that the privilege is vitiated? And the courts are now split. And I will tell you, there were two cases, and again, happy to give the actual cases to anybody who wants to read more on it, within a week of each other. One came out of the Eastern District of Michigan, and one came out of the Southern District of New York. And in the Eastern District of Michigan case, there was a civil defendant who sought to compel production of documents relating to whether this pro se plaintiff had used AI. The court analyzed it and said, you know what, I'm not going to compel production of that. The plaintiff's materials are protected under the work product doctrine. And the court found that because AI, in the court's view, is a tool and not a person, there was no loss of privilege merely by sharing information with the machine. And that makes some sense. And you might read that and say, okay, great, that's fantastic. 1 week later, the Southern District of New York had a different view. Now, this was in a case called United States versus Hepner. It was a criminal case. And the criminal defendant had uploaded documents and information to Claude, including information that his lawyer had provided him so that he could get some answers and communicate more effectively with the lawyer. That court went and examined the underlying policies of the AI tool. In that case, it was Anthropic, and found that because the defendant had agreed to those policies, and those policies said, we're going to collect inputs and outputs, and you don't have a right to privacy in any of this, that data, because it could be disclosed by this third party, by Anthropic via Claude, that caused a waiver of the privilege, and there was no protection, and the documents had to be produced. So you can imagine that when you're talking to your line of business and you're providing them with your best legal advice, and one of them decides they want to check your advice by asking ChatGPT or asking Claude, those conversations may, and I say may because this is evolving literally month by month, those conversations may ultimately not be privileged. And if you get into a discovery battle 6 months down the road and you have to produce the prompts and the questions and the results of those conversations, you can go from a perfectly defensible case to a situation where you have a lot of problems. And one example, we had a conversation with someone who said, I'm not going to tell you who, but I think I had a business person say, I'm pretty sure we did some things wrong here. What's the best story to cover that? It's perfectly understandable, right? But that's the kind of thing that if it comes out is going to create enormous problems. You need to advise your business folks. I would recommend at this point that we not engage in putting the lawyer's comments or anything that you think may be privileged into a third-party machine, because that's going to at least run the risk of waiver. So that's sort of the one side of the coin. Now, what's the other side of the coin? All of us as companies, when we get sued, have to produce information, some of which is trade secret, some of which is highly sensitive, some of which we just don't want produced for a whole variety of reasons. Historically, Gretchen and I would negotiate with the other side, and we would get a protective order, and we would get a confidentiality agreement, and they would say, we won't share these documents with the world, and we'll destroy them at the end of the case, or we'll give them back to you. That's the way everything worked, right? Here's the problem. Most of our adversaries on the plaintiff's side are now taking the document productions that we are making, and they are uploading them to AI and asking AI to synthesize those documents, to provide comments on those documents, to provide the legal theories that those documents fit into. And again, to the extent that the particular program they're using does not have adequate safeguards, there's a risk that your trade secrets, that your confidential information, that other information can then be leaked to the outside world and you've lost control over it. So one of the things you want to think about is before you start engaging in discovery, before you start producing information, and by the way, this works equally well if you're having a conversation subject to an NDA in a business context. You want to make sure that you've thought through the extent to which you're going to permit the other side to use AI to analyze the documents, and you at least have an understanding of that, because otherwise that information can wind up in the universe. Now, make sure you get your ethics credit. We'll actually mention some specific rules. There are a variety of opinions that both state bars and courts have issued over the last couple of years with respect to AI. I will tell you from a litigator's perspective, we not only have the rules that are out there, we also have specific judges have specific rules that we have to follow now. And this is all sort of developing as a patchwork. And so you really have to pay attention to it. But California, as we do, has actually gone a step further, and they have proposed amendments to the California Rules of Professional Conduct that would incorporate new commentary on the standards for attorneys. And again, happy to provide links to any of that, anybody who wants. The comment period actually just closed 3 days ago, beginning of this week. And so we expect to see those guidelines be refined and come into play probably later this year, maybe beginning of next year. And these fall into the sorts of things that most of you have done, looked at either recently or at some point when you were studying for the bar exam years ago. And those are competence, communication, confidentiality, candor, and supervision, the 4 C's and the S. So what are those and how those fit into AI? Well, duty of competence, the commentary is going to say that you have a duty to be familiar with new technologies. So even if you still have a VCR at home flashing 12 o'clock like I do, you have to know what AI is. You have to at least know the basics. You have to be reasonably competent, or at least minimally competent, with respect to new technologies. Communication. We have a duty, outside counsel has a duty to communicate with you. You have a duty to communicate with your clients, your internal business folks, about decision-making, strategy, developments, limitations. You have to be able to explain to your business clients what the strengths and potential risks of AI are. And again, that goes back to having some policies in place and then being able to have conversations with the line of business about precisely why we're suggesting, for example, that you not use AI and upload these documents. All of that is part of the duty of communication. Confidentiality. Touched on that. That's Rule 1.6. Touched on that a little bit in the last slide when we're talking about how you protect things, how you protect privilege, how you protect confidentiality. That duty, the guidelines are, we expect the guidelines are going to suggest that duty may actually specifically include not revealing confidential information to AI tools unless there are specific assurances that it will not go beyond that. So pay close attention when those guidelines come out to the extent to which that actually becomes a specific guideline for professional responsibility, because that will apply to all of us. Candor, again, this is more for outside lawyers. We have a duty to tell the courts the truth, and that includes if we're using AI, if we're using other tools, we have to be honest about that. Some courts are now actually requiring certifications that you notify the court if there's been AI used in anything that's submitted. And along those lines, I will make a personal plea. If you are, like many of my friends, the sort of in-house counsel that wants to revise briefs, which is fantastic, and there's a teamwork that's involved. If you have a junior person on your team who might use AI, please find that out and let your outside counsel know so that when we sign that certification, we know whether anything in the process has involved AI. That's the thing that's sort of often overlooked. And again, it protects everyone if we just know that the entire supply chain of thought that went into the filing has complied with the rule. And then, of course, 5.1, 5.3 is the supervision or the supervision rules. Those require that when we have a junior associate or a junior in-house lawyer who's working on something, that we supervise them in their use of AI tools and that we ensure that they are doing the right thing. So if you're considering using AI, if your outside counsel is, really suggest paying close attention to these guidelines when they come out. And obviously, we'll be happy to send a link to those to anybody. Gretchen?
Yeah, and so, when we talk about some of these ethical considerations, the one thing that we're seeing really more and more in a lot of federal courts, some of them are starting to impose requirements that a business person familiar with the company's systems actually attend the initial conference with the court. And I do believe that that is going to happen. We're going to see that, once a few courts start doing that, a lot of the courts will follow suit, because the courts are spending a lot more time in what I'm going to call discovery disputes over these kinds of things. Like, we're not having discovery disputes over emails. The discovery disputes that are occurring are over whether or not you need to go and produce things that have hyperlinks in them, or you need to produce, for those of you, because I know we have a lot of in-house lawyers that are in companies, therapeutic companies, where they've got a lot of development folks, or in IP cases where the versions of things become really important. Well, in the past, no one would ever really have to go and do versions or version control. And so courts are finding a lot of their time and effort is being spent on discovery disputes because the work wasn't done up front, despite what's in the rules about finding out what is involved. And so that's what we mean when we talk about competence. A lawyer has to make sure before they go to court, and in some cases, and I think part of the reason we're seeing courts do this is they've concluded a lot of lawyers are just completely not as competent as they need to be. And so they're saying, well, you know what, we're going to solve this problem and we're going to require the IT person to come. And that's also, I think, from an in-house lawyer perspective in terms of competence, one of the things that you can do is make sure that your IT people, you're educating your IT people about what these holds actually mean. A lot of holds get sent out, and the IT people, by definition, are automatically copied, but they don't take any action. That's one thing I've noticed. They get them, but whether or not they do anything with them is a totally different issue. And so it's not enough anymore to just send that litigation hold. You, as an in-house lawyer, because that's often where it happens. It doesn't happen, sometimes it does, but not always. A lot of times the damage is done before outside counsel is even on board. And it's going to have to be disclosed. And so, unfortunately for the in-house lawyers, you guys are going to be on the front lines of all of this. And these rules actually apply with equal force to you. We think of it as outside counsel because outside counsel are being sanctioned. But I can tell you, I have had judges want to know what in-house lawyers were involved in certain decisions. And it's not sometimes enough to say, well, it was the in-house lawyer at this company. I want names. So this gives you a clue of some of the disputes that I've had to deal with. Unfortunately, we always say, you do this long enough, there's always like the new thing. Well, the new thing right now is really dealing with what I call non-merits motions practice in the arena of spoliation, because it is just honestly very, very easy in this digital world to lose evidence. So what we do know is that this isn't going away, and that it is, as lawyers, we have to be on top of it and reading in some ways more than we want to on this subject, paying attention to court decisions. And the good news is people write on this a lot, so it's not hard to find it, but you do have to sort of take the time to figure it out. And so what I would say to all of you is, for those of you that have Teams and Slack, maybe after today, you're going to go find out what your automatic deletion policy is and figure out if maybe it needs to be a little bit longer. Because I know on our team's messages, they absolutely disappear after a period of time. So that I do know. So with that, I think we are almost at our time. Jason, do we have any comments in the chat from anyone that we need to address?
Nothing yet. If anybody has any quick questions, feel free, and we'll stay on for just a couple minutes afterwards.
Yeah. Anybody have any questions? I mean, you don't have to put it in the chat. You can just ask us if you do.
All right. Taking silence as our cue.
All
Thank
right.
you. Thank you, everyone, for attending. Hope it was helpful. And if you have any questions for any of us, our contact information is on the website. Happy to talk to any of you. I think our next social event is on September the 10th. So look out for an invite. I don't know where it will be, but would love to see all of you in person.
Yep.
Thank you.
Thanks, everyone.